Mistake number 7. Failing to take advantage of a preliminary hearing. A preliminary hearing, also called a probable cause hearing, is an opportunity for the defense attorney to ask questions of the prosecution's witnesses. The hearing is under oath, so the witness may be impeached at a later trial. If the hearing is successful, meaning that the charges are dropped, you will lose your bond. If unsuccessful, your bond remains. See mistake number 4. Most defendants do not want to win the hearing for this reason. Even if the charges are dropped, they can be brought back if the defendant is indicted by the grand jury. This is not considered double jeopardy. Instead, these defendants want to take advantage of the hearing by cross-examining the state's witnesses and hearing what they are going to say. The main purposes of a preliminary hearing are: 1. To learn what the witness will say at a later trial. 2. To investigate the truth of the testimony before a later trial. 3. To lock in the testimony of the witness for later impeachment. And 4. To seek a lower bond or lesser charges before the case is indicted in criminal court. Some attorneys flap a lot about how they are going to subpoena the state's witnesses to see if they dare to show up. Then, when the witnesses appear and it is time for the attorneys to have a preliminary hearing, these attorneys flinch and say, "You don't want to have this hearing." This opportunity should be more than just a gamble to see whether someone shows up. If the witnesses show up, then you should have the hearing in almost all cases. If you are planning to take your case to eventual trial, then the preliminary hearing is the opportunity to start prepping the case. Juries love it when a witness gets caught fibbing. The attorney has that high drama moment when he or she can say, "That's not what you said last time." The problem is that if there is no last time, there is no prior testimony to impeach. Unfortunately, some attorneys don't believe that certain defendants deserve a trial because their charges are not serious enough. They may say, "Oh, take the diversion and it comes off your record," when you still want to fight the case itself. A diversion is a wonderful thing, but if you want to fight the case first, then make that clear when you hire the attorney. This mindset actually punishes you for having a clean criminal record.